Well played. Hello, my friend. Perez Hilton here, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. The latest chess move in this very long game involves the basement manager's publicist, Leslie Sloan. Some of you remember that Justin Baldoni is not just suing the Cherokee Queen, self-proclaimed, but he's also suing her publicist. And as I've already told you, Leslie Sloan, her longtime rep, has filed a motion to be dismissed from this lawsuit. Good luck with that. The judge has not ruled yet, and I think that the judge should say, no, you are a key player in all of this. Sloan has argued that she just shared her opinion when she said that he was a sexual harasser and that none of the cast liked him. That was just her opinion when talking to reporters. That's not an opinion, babe. That was a declarative statement. If you didn't do well in school, look it up. And I was talking to Leslie Sloan, not you all. You all are very bright people. I know that. You are mommy sleuths and daddy sleuths. Or childless sleuths. We are Sherlock Holmesing this together. So, earlier today, Leslie Sloan's lawyer sent a letter to Judge Lyman, who's overseeing this all in federal court in New York, and her attorney has asked for a pause. The letter says, quote, "We respectfully request that the court stay discovery as to the Sloan parties until the court resolves their pending motion to dismiss." The Queen of Hearsay recently got that slight, not quite win when the judge granted her the attorney's eyes only designation. And Delulu's lawyer says that they are ready to begin with discovery. The publicist for the Woody Allen apologist does not share that sentiment, though. Oh my God. The parties conferred about this in good faith, meaning her desire to pause discovery. Miss Lively, Mr. Reynolds, and the New York Times Company consent to this request. Yeah, duh. Wayfarer Studios, Justin Baldoni, Jamie Heath, It Ends With Us movie, Melissa Nathan, Jennifer Abel, Steve Surrogates, together, the Wayfarer parties oppose. Courts have considerable discretion to stay discovery pending decision on a motion, blah, 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 blah. And the Floral Fanatics publicist is asking for a stay, not only because she's trying to get dismissed from this old lawsuit, but also because the discovery sought as to the Sloan parties is unduly burdensome and costly. I wonder if Pinocchio is paying for her publicist's legal bills. I think that the uncredited director of It Ends With Us should pay for it. Do you? Sloan's letter to the judge asking for a stay continues saying the Wayfarer parties served a striking 370 requests for production of documents and 18 interrogatories on the Sloan parties. His lawyers be keeping busy. The Wayfarer parties, 390, they counted. The Wayfarer party's 391 paragraph complaint alone confirms how burdensome discovery in this case will be. The judge has also said, remember this, when granting the AEO designation, the judge brought up how expensive this all is, but he ain't paying for any of it. I told you all, the billionaire co-founder of his studio, his production company, he's fronting all the legal bills. Now they're trying to kiss the judge's butt. Further, as Your Honor recently observed, the burden of discovery is compounded by, quote, the sensitivity of the documents that will be requested. Here, discovery is particularly burdensome because several of the Sloan party's direct business competitors are parties to this action, and discovery will necessarily include confidential and sensitive business information. But perhaps the strongest argument that Leslie Sloan makes is reminding the judge of his previous ruling. The New York Times, who also is still a party in this amended complaint, already went to the judge asking for a stay in their discovery. And the judge granted them that pause. So the former B-list actress's publicist is saying, me too, me too. You pause them, pause me. You pause them, pause me. As the court held in its recent order concerning the New York Times Company, its ruling on the pending motion to dismiss could drastically affect the scope of discovery as to the Sloan parties, because the dimensions of the discovery that is permitted may vary depending on whether they are defendant or a third party. And because of that, the Wayfarer parties should not receive the benefit of the less stringent standard for party discovery simply because they improperly named the Sloan parties in this action. Or so they assert. I assert that the Sloan parties definitely need to be a part of this action. Action, bata bata bon so I need some action. Who's old? Oh, that's my old people's. You. That's for us. My chemistry is can you call a chain reaction? Also, if the judge is so magnanimous as to do this, the Wayfarer parties, quote, will suffer little to no prejudice from the stay. Further, the proposed stay is limited to the time required for the court to decide the motion to dismiss, which is already fully briefed. The court has already indicated that it intends to decide the pending motions to dismiss quickly. And the Sloan parties have made every effort to accelerate resolution, filing their motion to dismiss on February 20th. Additionally, they lie, saying the Sloan party's role in the overall dispute is small. Not true. The Sloan parties have a far meatier role in all of this than the New York Times. Miss Lively's amended complaint discloses that Miss Sloan was not even aware of the sexual harassment as it happened. Ooh, and here's a bold allegation. And the Wayfarer parties do not and cannot allege that Miss Sloan was involved in the New York Times article that they claim is defamatory. They can and they have. The main parties in this dispute, Miss Lively and the Wayfarer parties, will not be seeking stays and can proceed with discovery without burdening the Sloan parties. Indeed, the Wayfarer parties have already served extensive discovery requests on Miss Lively, Mr. Reynolds, and 10 third parties. Y'all, in the meantime, it's evident that the parties will be busy with document discovery from the other parties and third-party discovery. So they're going to be so busy, they don't have time for me, Leslie Sloan. The Sloan parties respectfully submit they have presented substantial grounds for dismissal and made a strong showing that they are likely to succeed on the merits of their motion to dismiss. No. But fair is fair, and since the judge did grant the New York Times a stay, I think that Leslie Sloan, the publicist, should also be granted a stay. I think. What do you think? Let's discuss in the comments section, and we're still waiting for the judge to rule on the New York Times and if they will be dismissed or not. And I'm so curious if things are going to start leaking after discovery begins. Bring it. I've raised lots of interesting questions for you to think on and give me your feedback. See you in the comments.